a constitutional obligation to ensure that a by-election was held within a reasonable time. Okay, and he was happy that the government could be judicially reviewed in the circumstances of this case. Is everyone okay? So again, what I want you to note is the actual procedure and the obligation on the government to issue the writ was coming from legislation, not the Constitution. However, the court did say that inherent within the government's role in terms of filling seats and ensuring that the government and the Dáil functions properly is a constitutional obligation to issue the writs within a reasonable time. Okay, and you'll see 208 talks about this fact that what we were talking here was a legal obligation that the court actually transferred to a constitutional obligation as well. Okay, the next one then is Kavanagh, and this involved the Special Criminal Court. Now remember what I told you under Article 38.3, the Special Criminal Court is basically a matter for the legislature, and it's also a matter for the government as well. And if you look at the quotation on page 24, this is the one we want to look at. And it basically outlined what the Special Criminal Court procedure is. It says that under our system, the question of whether the Special Criminal Courts should be established is for the legislature. So the initial decision to establish the Special Criminal Court, because it's not listed in the Constitution, what the Constitution does is it gives the power to the Oireachtas to bring in special courts if it believes that the ordinary courts aren't adequate to administer justice. A decision was made in 1939 to bring the Special Criminal Court into effect. The Oireachtas made that initial decision. Then the legislation that brought in the Special Criminal Court handed over the question of establishing bringing the Special Criminal Court into force over to the government. You'll see that there in the quotation. So what they said was that the power of the government to bring the Special Criminal Court into effect must be exercised in a bona fide matter where the ordinary courts aren't adequate to deal with the matter. The court said, if you look down through the quotation, it says it's primarily a political question. Can you see that? It's about halfway down in the quotation. Then he goes on and says, the government is not acting judicially in the sense that it is adjudicating upon the rights of any particular citizen. Rather, it is making a political judgment on the adequacy of the ordinary courts. Drop down a bit. It is natural that such a political decision should be primarily subject to political control. So here what we have is we have the court saying, look, under the Constitution, the power to instigate in the very beginning a special court and give it the name, they decided to give it the name Special Criminal Court, was given to the Oireachtas. When the Oireachtas were enacting the legislation, they transferred the power to call into effect this Special Criminal Court to the government. And the court here said, look, by virtue of the provisions of that act, calling into effect the Special Criminal Court and keeping it going. And remember, it's only supposed to be there when the ordinary courts aren't adequate. So if you keep it going, it's like a constant statement. The ordinary courts still aren't adequate to deal with these matters. We need this Special Criminal Court to deal with them. And what the court said here is that decision about whether the ordinary courts still aren't adequate to deal with the matter, and so we still need to keep the Special Criminal Court going, is a political decision and one which only the government would make, not a judicial matter which the court. Now, you could argue that when the court said here that they're not acting judicially in the sense that it's adjudicating upon the rights of any citizen. Now, okay, it isn't adjudicating on the rights of any citizen, but what do people have? What right do you have in relation to a serious or a non-minor offence? Right to trial by jury. If you're before the Special Criminal Court, what do you not have? Right to a trial by jury. So there are, to a certain extent, effects on constitutional rights, because if you're brought before the Central Criminal Court, you have your right to a jury trial. However, if the Central Criminal Court is deemed not to be adequate and yours is an offence which has to go before the Special Criminal Court, then obviously they're saying the ordinary courts aren't adequate. This is why we're sending you to the Special Criminal Court. But by virtue of being sent to the Special Criminal Court, all of a sudden your right to a jury trial is gone. You're going to be tried by judge. Does everyone understand? So it's not, some people argue that, so what he was saying is here is that the continuance of the Special Criminal Court and the decision about sending your case to the Special Criminal Court is a political one, not something the courts need to adjudicate because it doesn't impact on the rights of any citizens. I would argue that you could say it does have an impact on your right to a jury trial. John would love comments like that. Okay, so if you want to scribble just at the side, question mark, right to a jury trial. We'll be doing about your right to a jury trial later on. Now, what we're going to take a look at is, now remember there that the power to the government to continue the Special Criminal Court in effect was coming from a piece of legislation. But now we're going to take a look at cases where the power is actually coming, the power which the government or the executive are exercising is actually coming from the Constitution itself. And this is Brennan. And this was to do with the power to commute or remit sentences. Now, when you look at this is all in the manual, when you look at Article 13.6 of the Constitution, which is given to you at the end of the page there, you see that it actually was originally vested in the President, but it may be conferred by law on other authorities. And that was used, and it was also transferred, it was given to the government, who in turn handed it down to the Minister for Justice. Okay, so the power to remit or commute sentences was, through the Constitution, it could permissibly be passed down, and it was passed down all the way to the Minister for Justice. So in this case, Brennan was challenging a system whereby the Minister for Justice exercised his power of remission over sentences which had been imposed on an applicant. And what happened here was the court said that there was no problem per se with the executive exercising the power to commute or the power to remit, because the Constitution specifically allowed for it to be passed on to other authorities, and other authorities would include the government. However, they had a difficulty with the way the minister was exercising his power. Okay, and you'll see that at the top of 25. The court held that whereas this was an executive power, Article 13.6 was never intended to create a parallel or alternative system of justice. So in theory, there was nothing wrong with the minister exercising the power to remit or commute, because the Constitution allowed for that. It was the way he was doing it was deemed to be invalid. Okay? Now, Reardon versus Ireland. What you just need to note about this case is we need to actually look at what is the status of what the executive is doing. And this is why the executive is very tricky, and I'm surprised John hasn't put it on. So we need to look at the status about what exactly the executive is doing. And we look at the Reardon case. And in this one, it involved a challenge to the validity of a nomination of a former judge to the European Investment Bank. Okay? Now, when we look at the quotation here, you'll see the Supreme Court said, look at, what is just being done here is a recommendation by the government to European authority that if they're looking for a judge to sit on an executive body like the European Investment Bank, they think Justice O'Flaherty would be up to the job. So the court said here, look at, this is just a political decision. This is a national executive talking to a European executive body and saying, look, if you're looking for somebody to fill that position, we've got a great guy here who can do it for you. So look within the quotation here. The government collectively or individual ministers may, over a huge area of activity, indicate their wishes or preferences. Now that's very important, to other bodies or persons, and it would be a remarkable and novel step for a court to take it upon itself to declare political decisions of this nature unlawful. So the thing you need to note here is the status of what the government was just doing here was just a recommendation or a preference. Okay, it had no effect in law. Okay, does everyone understand that? Okay, now that's very important. We're going to see why when we look at the area of international relations. Okay, so the thing to note about Reardon is that this was just the status of a recommendation or a preference going from one executive body at national level to an executive body at European level. It had no legal effect, it had no impact on the citizens of Ireland. Okay, now the non-justicability issue we're taking a look at, and this is also the issue of socio-economic rights, and it's huge. Okay, I think John has only actually examined it once, but it's a highly examinable topic, and it's with all of these education cases that are being taken and lost, it's becoming a more examinable topic. And you'll see, yeah, it came up once.